So, Article 50 TU requires that the notification of intention to leave is to be in accordance with the constitutional requirements of the departing member state. Now, we were not entirely clear what those constitutional requirements are in the UK. The power to enter into international agreements is an executive power in the UK's constitution. This question was settled in the Miller 1 case, which was decided by the UK Supreme Court in 2017. The judgment meant that Prime Minister May could not begin talks with the European Union until MPs and peers gave their backing in the form of an Act of Parliament. But the Supreme Court also ruled in that case that the Scottish Parliament and Welsh and Northern Irish assemblies did not need a say. Brexit Secretary David Davis promised a parliamentary bill within days. This was enacted as the European Union Notification of Withdrawal Act 2017, which received royal assent on the 16th of March 2017. The Act confers power on the Prime Minister to notify, under Article 52 of the Treaty on European Union, the United Kingdom's intention to withdraw from the EU. On the 29th of March 2017, Prime Minister May wrote to Donald Tusk stating the UK's intention to leave the EU. The letter included that the United Kingdom wants to agree with the European Union a deep and special partnership that takes in both economic and security cooperation. To achieve this, the letter went on to say, we believe it is necessary to agree the terms of our future partnership alongside those of our withdrawal from the EU. This line of the letter does not take into account the wording of Article 50 TEU, especially as that wording was interpreted by the EU as things unfolded. The 27 member states of the EU agreed the EU's negotiating position in April 2017. This negotiating position legally bound the European Commission. The 27 EU member states remained very united in the agreed EU negotiating position all the way through the negotiation of the withdrawal agreement and indeed beyond, but more on that later. Attempts by Prime Ministers May and Johnson to speak separately with heads of state of key EU countries did not have much success. The EU's negotiating position included several key principles that legally shaped the negotiations and the outcome in the withdrawal agreement, as well as negotiations on the future EU-UK trade agreement. One important principle is that nothing is agreed until everything is agreed. This principle apparently gave the EU and the UK important flexibility to offset what one party wanted in one part of the agreement against what was wanted in another part. It was different from the usual way in which the EU negotiates trade and other agreements, where each chapter of the agreement is closed as the negotiations progress. Second, the European Union was firm that the single EU internal market must remain protected. This meant that there was no scope for sector-by-sector deals. The internal market, as you will recall, is defined in European Union law as an area in which all factors of production, products, services, capital, and crucially, people, may move without unjustified hindrance. And third, the European Union insisted upon the "you cannot have your cake and eat it" principle. A non-member of the European Union that does not live up to the same obligations as a member cannot have the same rights and enjoy the same benefits as a member state. According to this part of the negotiating position, there is no legal category of departing member state or ex-member state. Once outside the European Union, the United Kingdom could be treated like an EFTA state, states which accept the disciplines of the internal market and its law, like Norway, or as an ordinary third country, like Canada or Japan, or any other country with which the European Union has one or more agreements. Fourthly, the withdrawal agreement was to be based on a rule-based approach. The withdrawal agreement had to respect the autonomy of European Union law as articulated by the European Court of Justice. This approach to the withdrawal agreement was critical to protecting the rights of human beings whose lives were disrupted by the UK leaving the EU. The citizens' rights part of the withdrawal agreement last for much longer than most of the rest of the withdrawal agreement, as we will see in a minute. The EU's negotiating position for the withdrawal agreement was based on a phased approach. This was, according to the European Union, required by Article 50, although it is not explicitly stated in the text of Article 50. Phase 1 was to provide as much clarity and legal certainty as possible to citizens, businesses, stakeholders, and international partners on the immediate effects of the UK's withdrawal from the European Union. Phase 2 was to settle the disentanglement of the United Kingdom from the Union and from all the rights and obligations the United Kingdom derives from commitments undertaken as a member state. And Phase 3 was to agree on an overall understanding on the framework for the future relationship. The European Union took the position that no discussion of Phase 3, even in principle, could take place until the key elements of the withdrawal agreement had been settled. These were, in brief, the rights of EU citizens in the UK and UK citizens in the EU and those of their families, a settlement for the island of Ireland, where the only land border between the EU and the UK is, an agreement on payments from the UK, and other key things like Gibraltar. This phased approach was not what the UK wanted for the negotiation of the withdrawal agreement. The UK wanted to negotiate withdrawal and the future relationship together. Again, we can see that the European Union relied on the notion of being bound by the rule of law to secure its negotiating position, to keep the governments of the EU 27 on side with that negotiating position, and to ensure that this was the way that negotiations actually took place. On the 8th of December 2017, the European Union announced that sufficient progress had been made to move to Phase 3, a political statement on the broad parameters of the future relationship. This statement was made with the caveat that nothing is agreed until everything is agreed. And so the joint commitments set out in this joint report had to be reflected in the withdrawal agreement in full detail. So the European Union's negotiating position was clear, transparent, and based on rules and principles. We could contest some of those rules, and people have, for example, the phased approach. Are the rules on free movement of people and citizenship of the European Union really integral to the single European market? But they are clearly articulated, and they're easy to understand. By contrast, the UK's negotiating position was very difficult to follow and to understand. The slide indicates some articulations of the UK's position. They start with the gnomic "Brexit means Brexit" in Prime Minister May's June 2016 leadership campaign. In her January 2017 Lancaster House speech, Prime Minister May talked of leaving the EU but not leaving Europe, a new and equal partnership, control of our own laws, maintaining the common travel area with Ireland, controlling immigration, a bold and ambitious free trade agreement, not membership of the single market or the customs union, continued security cooperation, agreement about a future partnership within the 2-year Article 50 process, a new and strategic partnership. And she said, threatening the possibility that the UK could leave the EU without securing a withdrawal agreement, no deal for Britain is better than a bad deal for Britain. To go to transparency, this speech was eventually published on the government website under the heading, "The Government's Negotiating Objectives for Exiting the EU." But it wasn't clear at the time that the speech was being made that this was what it was. In June 2017, in the Queen's speech, the following statement was included. The fact is that over 80% of the electorate backed the two major parties, both of whom campaigned on manifestos that said we should honour the democratic decision of the British people. While this will be a government that consults and listens, we are clear that we are going to see Brexit through. That meant that there would be a European Union withdrawal bill and other bills on customs and immigrations and so on introduced in that parliament. In September 2017, Prime Minister May made another speech in Florence in which she stressed that the United Kingdom was seeking a deep and special partnership encompassing trade and security. The then Prime Minister stressed the need to move on to the next phase, for the trade relationship to start from the unprecedented position of having the same rules and regulations as the European Union, which will be carried over into UK law under the EU withdrawal bill. The Prime Minister said that Norway or Canada was an unimaginative choice and suggested a more creative, practical solution involving high regulatory standards and a transition period, which the UK insisted on calling the implementation period, for the purposes of securing certainty. This creative narrative, stressing that the UK is different from other states, is directly at odds with the European Union's rule-based approach and the principle of no cake and eat it. Then in July 2018, almost a whole year later, we had the Chequers proposal, also known as the Chequers Agreement, because it was agreed within the UK Cabinet. This was published as a white paper. The white paper suggested that the future EU-UK relationship could be in the form of an association agreement, but the future relationship is likely to consist of a number of separate agreements, each covering different elements of economic, security, and cross-cutting cooperation. So this encompasses an economic partnership and a security partnership. The economic side covers goods and services and a mobility framework for people. Free trade area for goods and a frictionless border are desired. The desire to avoid a hard border, more about this later, on the island of Ireland was stated. There should be, says the white paper, a common rule book for goods. Services market might diverge. There would be less access for the UK to EU27 markets for services and vice versa. The security side proposes that the UK remains a partner to the European Union for its foreign and security policy, for data sharing of criminal enforcement agencies, and so on. New cooperative accords between the European Union on data sharing, on science and technology, on education, and so on were all desired, and also on fisheries. The white paper carried on. These arrangements should reflect that the UK will no longer be a member of the EU. The EU institutions, including the Court of Justice, will no longer have the power to make laws for the UK, and the principles of direct effect and supremacy of EU law will no longer apply in the UK. The new institutional agreements should respect the UK's sovereignty and the EU's autonomy, and be sufficiently rigorous that people across the UK and its wider family and across the EU and its member states can depend on them. The white paper suggested that some agreements should be legally binding on the UK and the EU, and others should be based only on political commitments, like in foreign policy. The white paper proposed dispute resolution through a joint committee, which would oversee technical rules between the UK and the EU, and that would be overseen by a political governing body. Again, we can see that the white paper is at odds with the European Union's negotiating position. The white paper argues that the withdrawal agreement and the future relationship must be agreed at the same time. And it also reflects this creativity point. The UK's arrangements with the EU, says the white paper, should not be constrained by existing European Union free trade agreement precedents. Again, to repeat myself, this ignores the EU's approach under Article 50 and the rule of law, and the notion that the European Union is a rules-based organisation. Johnson's election campaign was to the effect that the UK should leave the EU with or without a withdrawal agreement. The 2019 Conservative Party election campaign slogan of "Get Brexit Done" and the Conservative Party victory in that election meant that the UK would be out of the EU by no later than the 30th of January 2020. So the EU and the UK appeared to be talking past each other. The EU talks of existing models and its negotiating position. The UK talks of a new model based on the fact that there has never been an ex-member state before. There are very interesting insights on the general difficulties of the UK and the EU negotiators to understand each other from regular reporting of the ways in which May's and Johnson's government appeared to misunderstand both the politics and the law of the situation. For example, the Frankfurter Allgemeine Zeitung's reports of the May-Juncker dinner on the 29th of April 2017 suggested that Juncker thinks May is in a different galaxy about what is possible. the European Union held firm to its negotiating position. Michel Barnier, the European Commission's chief negotiator, repeated in a speech in September 2017, the EU has trade agreements with many countries. Barnier mentions Canada and Norway, but he warns it will not be possible for a third country to have the same benefits of the Norwegian model, but the limited obligations of the Canadian model. And Barnier again in a speech in October 2017, the moment the UK chooses no single market and no customs union, we will have to work on a model that is closer to the agreement signed with Canada. Again, the European Union negotiating team articulated repeatedly that the European Union as an organisation is based on the rule of law. The negotiations for the EU were and are not just about political expediency or what could be achieved as a rational economic actor maximising benefits. There is also a sociological dimension, commitment to the idea of Europe, peace building through cooperation, not just the economy. And underpinning that commitment is a commitment to the rule of law. And because of all of that, we didn't know until the 8th of December 2017 whether there would be a withdrawal agreement at all. Agreement in principle on a withdrawal agreement was announced in December 2017.